The situation regarding Russell Brand is becoming more and more interesting as each day passes, for reasons I'll explain in this video. But what I'll also explain in this video is why you should either think very carefully or choose not to give your opinions online as to whether you think he's innocent or guilty. As I said, I'll explain why in this video. But the reason this is becoming very interesting is for what many people describe as government overreach, or what they believe to be government overreach. Whilst it may not be the government itself, certainly with the letters that have been written by parliamentary committees and now a publication by the Attorney General warning people about what I'm going to describe to you in this video, it's certainly getting very interesting to me. So what on earth are we talking about? Broadly speaking, I'm talking about contempt of court. Now, contempt of court is set out in the Contempt of Court Act, but in short, it means if you make any kind of publication, which could include any kind of speech, any kind of writing, any communication in whatever form to either the whole public, the public at large, or any section of the public, and it has a substantial risk or creates a substantial risk that it could interfere with active proceedings, you might be held in contempt of court. The question here, of course, is Russell Brand has not been arrested and he's not been charged. And so far as we know, he's not even yet been interviewed, although there's a rumor that I'm going to come on to very shortly as to whether the Met Police are investigating. I'll set that out in another video. But an active case, an active criminal case, is when a person is arrested or an arrest warrant is issued or a summons is issued. That means it's insisting that they come to court. Or if a person is charged orally. All of these are steps that mean that there is a real prospect that this person is going to face a criminal trial. That would make these proceedings active. Now, the interesting thing here is, two things really. The Contempt of Court Act provides that this is a strict liability rule, meaning it doesn't matter if you intended to cause disruption to these proceedings or not. If what you said publicly or you wrote or whatever communication form you used, you communicated something that interfered with the proceedings, whether you intended for that to have an effect on the proceedings or not, you could still be held in contempt of court. Now, as I said, one of the reasons this has become very interesting is that there is now a press release from the Attorney General confirming the requirements not to publish material which could prejudice any potential criminal investigation or prosecutions. And as I said, ordinarily, the Contempt of Court Act applies to active proceedings. But here, the Attorney General is quite clearly saying that publishing material that could risk or prejudice any potential criminal investigation or prosecution could amount to contempt of court, which means if you do that, you could be held in contempt of court, meaning you could be sent to prison. However, there is a very strong argument that, well, for and against, there's an argument for and against, there usually is, that contempt of court can arise out of common law. Now, indeed, both the CPS website refers to common law contempt, which is where proceedings are pending or imminent, albeit not necessarily active for the purposes of the Act. Now, pending or imminent means there could well be a case to be brought, but is not yet active, as in there's not yet been an arrest, there's not yet an arrest warrant, there's no summons, and no one's charged. In this case, Russell Brand has not been any of those things as yet. So none of those things. So it is not active for the purposes of the legislation, but that's not to say it's not a pending or imminent case. Contempt of court under common law would mean that if you publish something that jeopardizes any potential pending imminent case, you could still be held in contempt of court. Indeed, this is also the case if we go to the guidance, the Law Commission guidance on contempt for non-specialists. So in other words, an overview. If we were to look at, let me get the sidebar up here. If we were to look at this paragraph here, again, it refers to the common law contempt. So the other form of common contempt by publication is covered by the common law. That is judge-made law. Watch the comment section go crazy. Under this law, it's contempt to publish information with the deliberate aim of impeding or prejudicing a case, even if the case is not active. Now, there's a lot of commentary online that this common law was superseded by the Act, because an Act of Parliament will usually codify, potentially repeal some previous common law and solidify what the law is from that point forward. Now, of course, this was in 1981, the Contempt of Court Act 1981. So there is an argument that this common law no longer applies since this act. However, there is also an argument that if this comes to court, that judges are not going to agree with that, because it would fetter their authority to uphold those decisions and restrict what they are able to do with regard to what might amount to contempt of court, albeit with a case that is not yet active. So in other words, if you were to publish something that would prejudice a case that is either active or even not yet active, so imminent or pending, and I don't think it's a stretch of anyone's imagination, and certainly not contempt of court, to say that it's entirely possible that there is going to be a case here because of the allegations against him, because the police are going to be prompted by this to investigate, and it's their job to investigate, and doubtless having these allegations published, there may be more complainants coming forward with more information, and so on and so on. Not to say that those are going to be valid complaints. That's not to say that they are going to be real. And it isn't to say that they're not real either. As I've said in previous videos, we do not know, and we cannot really pass opinion on that. Now, if, for example, I were to pass opinion and say, well, this is what I think of, X, Y, and Z, so long as it doesn't cross the threshold of creating a substantial risk of prejudice to the either live or pending case, then it wouldn't be contempt of court. But if you were to say something, and many people do pass their opinion quite heavily and push that opinion often with no basis and with no real analysis, and they put their opinion out there for or against, that could well amount to contempt, even if a case is not yet active, under the argument that the common law contempt can still apply. Now, as I said, there is an argument that it won't, and many leading commentators have said that this doesn't apply and hasn't applied for some time. But let me just say that I wouldn't want to be the one to find out if I were to test the bounds of that and then be standing before a judge to decide whether or not they will uphold the common law contempt when it is still put out by the Law Commission, and it is still talked of by the CPS. It is still very much a subject matter of discussion to be held in contempt for publishing something that creates a prejudice for a case that's not yet active. Now, as I said, this is from the Attorney General. Now, there's been pressure, I believe, from the Times to retract this statement, to argue that it has no basis in law. For reasons I've outlined in this video, I don't entirely agree with that, because the common law contempt may still very well apply, as it is warned of just here. So it does outline here that any editors, publishers, social media users even should take legal advice to ensure that they're in a position to fully comply with the obligations to which they are subject under the Common Law and Contempt of Court Act 1981. Now, make no mistake, this video is certainly not advice. My warning to you, my guidance to you, is that unless you want to risk going to prison for being outwardly, firmly giving your opinions online, and risk going to prison for contempt of court, if it were found that that were to jeopardize and prejudice a case, unless you're willing to take that risk, I would keep opinions to yourself. Unless you've taken that advice and unless you are absolutely sure there's no way that what you say is going to prejudice these proceedings, whether active or not. So as I said, an interesting one, because this is a very unusual situation that we find ourselves in. Having the letters gone to private companies to ask questions as to whether his monetization is being suspended, and now a media advisory notice to the public at large, which I feel obliged to talk to you about and raise awareness of. And my guidance on this would be, as I've said, that I would not, if I were in your shoes, wanting to post your opinions online, I would not want to be the one to find out. If you were a client of mine, that would be what I'd say to you. I would not want to take the risk just for voicing an opinion of going to prison if you are found in contempt for a case that is not yet even active. And that is the strangest thing about all of this. He has not been arrested. He has not been charged. So far as I know, there is no arrest warrant. There is no summons. It's all purely on the back of these allegations. So as I said, I hope you found that interesting and slightly scary, perhaps, because I feel that this is new territory and new waters for this sort of thing, and potentially a direct threat to what you might want to say online in case it prejudices proceedings. But I hope you found that interesting. Please do consider hitting the like button and subscribe, and maybe we'll talk a little bit more about this and in future videos. But leave any comments, questions, as always, and as always, thank you for watching.